Do police need a search warrant to look in someone's backyard? Well, that takes us to this week's case. It involves a real man, real case. Quentin Todd Chute, a man living in Minnesota. Well, the police were looking for a stolen camper. And the camper that met that description was seen in the back of Quentin's home. So the police one day went to the property, went directly to the back of the house, and saw the camper. It met the description. Quentin was arrested and was then prosecuted for having possession of stolen property. Now, Quentin, through his attorneys, argued that was an illegal search. It was an illegal search because the police did not have a search warrant. They didn't have a search warrant, and they entered my property. And the argument made by his attorney was that the police violated the curtilage of the property in order to conduct the search. Now, what is curtilage of a property? Well, it's a concept that exists in the common law, and it's a concept that basically says that the privacy which attaches to someone's dwelling place also attaches to the property immediately surrounding the property. I mean, back in some old days and in some areas of the country where that property is fenced off, you can actually see, well, that's the curtilage of the property. In many areas, however, there is not a fence, and it's defined as that area immediately adjacent to someone's dwelling place, and it can include some structures that are immediately adjacent, like a garage, like a storage shed. But it doesn't include the outlying fields. Doesn't include the outlying fields. And now is when we get into some big issues about where does the curtilage exist and where does the curtilage not exist. And in this case, the lawyers on behalf of Quentin Chute were arguing, hey, the curtilage extended clearly to the backyard, and the prosecutor was arguing on the other side, no, 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 that was a big backyard, and the curtilage stopped short of that full big backyard. Well, the case went up to the Minnesota Supreme Court, and there the Minnesota Supreme Court had to hear both these arguments. It heard both these arguments, looked at what had taken place, and they found that the police had entered the property and went directly to the backyard and began searching the camper. And as the Minnesota Supreme Court ruled, it's not like they went to the front door just to knock, which you can do, that's violating the curtilage, but you can do that in order to get permission to be on the property. But here they went just to the backyard to look for that camper, and the Supreme Court came away and they agreed with the attorneys for Quentin Chute, and they said, yes, that was a violation of the property, that was therefore an unlawful search because the police did not have a search warrant. Now, there was a dissent. One of the justices said that, in her opinion, that the curtilage actually had stopped short of what she said was an open field, and that, in fact, the search was lawful because it was a search of an open field adjacent to the residence. Okay. So what do we learn from this? What we learn from this is a very important concept, and that is when it comes to search and seizure, when it comes to searches, there is this concept of a curtilage, and it's that area that immediately surrounds a home, immediately surrounds a dwelling place. And that is as sacrosanct under the Fourth Amendment as is the inside of a house. And the police must have probable cause in order to enter that area or must have a search warrant before they can enter that area. All right, bring you this case and bring you cases every week so you understand how the law works. I'm David Allen.